Hello, future paralegals, and welcome to a segment of Ask Your Stupid Questions. So, for those of you who aren't familiar with what this is, Pretty Paralegal offers a how to pass a paralegal licensing exam prep program. And usually, what that includes is about 6 hours of online video tutorials. They're demonstrative, as well as modules to work on your mindsets, review tips and tricks, as well as secret study strategies, and an 8 rule, kind of like 8 step system for how to answer exam questions quickly and correctly. So after that, students then participate in a 5-week in-class course where we do some law review as well as practice tests applying the 8 rules. We do some one-on-one sessions as well as some live video Zoom calls, and a few weeks before the actual exam, we have our Ask Stupid Questions portion of the program, which is where students are able to write in their questions and receive a video response. And so that's what this is. And these responses will be made public to pupils who haven't participated in this program, just because you never know, these questions might be helpful to you. So why do we call it Ask Stupid Questions? The reason why is because, oftentimes we won't understand something, or maybe something isn't clear, or we can't find it in our materials, but we want to understand it. But we feel like we can't ask the questions because we don't want to seem stupid. And people always say, oh, I have a stupid question. And people often say, well, there's no such thing as stupid questions. So what this is designed to do is to encourage you to ask the questions that you may not otherwise ask, because that's how you learn. The only thing stupid is to not ask a question about something you don't understand, or to receive a response and not write it down and practice it or apply it. In this process, I also encourage pupils to try and find the answers themselves. It's too easy. It's a little lazy if we just ask the question without actually trying to find the answer, especially in a profession that requires us to perform research. You need to develop those skills. So if you have a question, ask the question, but see if you can find the answer first. And if you come across something that you struggled with, that you think might help the rest of the group, then please, by all means, share it. So let's get started. So one student asked the question, is a paralegal considered a student of law? So let's start by defining what a student of law is. A student of law is any person who is studying law at an accredited law school. So they're not yet lawyers, they are students of law. So by that definition, a paralegal would not be a student of law, because a paralegal, to be able to call yourself a paralegal, denotes that you've already completed an accredited paralegal program, have written the licensing exam, passed it, and have become an official member of the Law Society. It is only when you are a licensed member of the Law Society that you are a paralegal. So paralegals are not students of law, just like lawyers are not students of law. But before they became lawyers, they were students of law, studying law at an accredited law school.
So just bear with me. I switched cameras, so the quality might go down just a wee bit because I had a little glitch. So moving on to our next question. The question that was asked is whether a paralegal may represent a family member without being compensated for it. So based on the wording of this question, it reads that the question actually being asked is not whether a paralegal can represent a family member, which we can, as long as the matter is within the paralegal scope of practice, But the question reads more like it seems that the question is asking whether a family member can be represented pro bono. So you should all know what pro bono means. Pro bono means that you are performing unpaid work. The short answer is yes. A paralegal may represent a family member pro bono. A paralegal may represent any member of the public pro bono, so long as the matter that you're representing them for is within the paralegal scope. There are other factors that need to be considered when representing a family member, friend, or any person who you have a close relationship with. I'm going to reference Rule 3.04, subsection 1, which is about the avoidance of conflict of interest. It states that a paralegal shall not act or continue to act for a client where there is a conflict of interest, except as permitted under this rule. So what does this mean? So the rules do not prohibit a paralegal from providing legal services to friends or family members, but they do require the paralegal to avoid existing or potential conflicts of interest. A conflict of interest may arise in this case when a paralegal provides legal services to a friend or family member, or when the client and the paralegal have a sexual or intimate personal relationship. So in these circumstances, the paralegal's personal feelings for the client may impede the paralegal's ability to provide objective, disinterested professional advice to the client. So before accepting a retainer from or continuing a retainer with a person with whom a paralegal has a sexual or intimate personal relationship, a paralegal should consider the following factors. Factor 1 is the vulnerability of the client, both emotional and economic. Factor 2, the fact that the paralegal and client relationship may create a power imbalance in favor of the paralegal, or in some circumstances in favor of the client. And you have to consider how that would affect the matter or your ability to provide legal services for that matter. Factor number 3, whether the sexual or intimate personal relationship may jeopardize the client's right to have all information concerning the client's business and affairs held in strict confidence. For example, the existence of the personal relationship may obscure whether certain information was acquired by the paralegal in the course of the paralegal and client relationship. Factor number 4, whether such a relationship may require the paralegal to act as a witness in the proceedings. Now that's a big one. If you are representing a family member, let's say, about a particular matter that you have firsthand knowledge about, you may have to be, or you may unintentionally be, a witness to that matter. And in that case, you cannot act as both representative and witness. So that's something else you have to consider. And factor number 5 is whether such a relationship may interfere with the paralegal's fiduciary obligations to the client, including his or her ability to exercise independent professional judgment and his or her ability to fulfill obligations to the administration of justice. Back to the original question, yes, as a paralegal, you may represent a family member without charging them a fee for your services. However, please consider carefully whether the matter calls for another paralegal to be representing your relative, to ensure the administration of justice, to ensure that no conflicts arise, to ensure that the services provided are professional and objective and impartial, and that you as a paralegal aren't just being driven by your emotions because you want to fight for this family member, and that you're not kind of creating some sort of a bias that will prevent you from providing the proper professional services? That's a tricky one. This is a good question. Very tricky circumstance. It's sort of like a fine line sometimes, and I've been in that situation myself. And it's tricky because you want to help. You want to help someone that you care about. And back to the point of pro bono work or unpaid work, you can offer that. I don't necessarily recommend it in all circumstances because so much of the work that we do involves some kind of litigation, right? There are so many costs associated with that. And I think clients often come into this process not being fully aware of the fact that this is really going to cost them. It's like they know it, but they don't truly appreciate the cost and the time that goes in. And when people aren't paying for your services, they'll take liberties with your time. You know, if they know that it's costing them something, even if it's a nominal fee, they're going to be more attentive when they have a phone call with you about their matter. They're not going to take advantage at family dinners to talk about their case and kind of drag that on for hours and hours when that's your downtime. So that's something else you should consider. Plus, oftentimes when you offer to do work for free or pro bono or even on contingency, what happens is you end up financing your client's case. So you have to ask yourself whether that's something you can actually afford to do. Are you in a position to pay for all the disbursements and other expenses that come along with providing the work? The photocopying, the binding, the mailing, the filing fees. If it is not clearly expressed to your family member that there are very specific costs that add up and that they are required to pay for those costs, it'll be sort of like out of sight, out of mind. They will not turn their minds to it. And the minute you ask them for money, they're going to get very upset and say, well, you offered to help me. You know, be very careful of that word help. When people say, can you help me? It's so yes, you can do it. I don't necessarily recommend it in all cases. So question number 3 asks, can you appeal an LPAT decision, or is it final? Does it go to the divisional court? So first of all, for those of you who aren't aware of what LPAT stands for, it stands for the Local Planning Appeal Tribunal, which is an adjudicative tribunal that hears cases in relation to a range of municipal planning, financial, and land matters. So the LPAT is part of the Environment and Land Tribunals of Ontario, the ELTO, a cluster of tribunals that adjudicate matters related to land use, planning, environmental and heritage protection, property assessment, land valuation, and other matters. It was formerly known as the Ontario Municipal Board, the OMB, quite recently actually. So the OMB was an independent adjudicative tribunal that conducted hearings and made decisions on land use planning issues and other matters. It was also Ontario's first independent quasi-judicial administrative tribunal. So a little bit of history there. So if your appeal is determined to be invalid, like if the LPAT informs you that your appeal is not valid and you disagree with the decision, then you may challenge the decision by making a motion to the LPAT within 15 days of receiving the letter. So even after a decision is made on your appeal, you can still motion for it to be reconsidered. So you would have to refer to Rule 10 and 26.08 of the LPAT Rules of Practice and Procedure for more information on how to challenge LPAT's determination that an appeal is not valid. Now, if your appeal is determined to be valid, then the LPAT will inform you, and at that point you will have to file an appeal record and case synopsis with the LPAT and follow rules 26.11 to 26.13 of the LPAT Rules of Practice and Procedure. And if you have any questions about those documents, you can actually call them directly or use the inquiry form on their website. If you're appealing official plans, or like official plan amendments, zoning bylaws, zoning amendments, then the LPAT is required to hold a case management conference. For appeals of other types, a pre-hearing conference may be scheduled. If the LPAT determines that an oral hearing is required, it will schedule a location either at the LPAT's office in Toronto or an office somewhere in the municipality. And after the hearing, the LPAT will issue a decision which would approve or dismiss the appeal. For appeals of official plans, or official plan amendments, zoning bylaws, or zoning bylaw amendments, the municipality or approval authority may make another decision. And these decisions could be subjected to a second appeal at the LPAT. So they have a process in place which you wouldn't just go directly to the divisional court. There's a process for appealing an appeal, in a sense, within the tribunal. Okay. So question number 4. Under the CDSA Act, so that's kind of redundant because CDSA stands for Controlled Drug and Substances Act. So it would just be under the CDSA. In what circumstances must a judge provide a reason for a sentencing decision when there is no mandatory minimum? And this is a perfect example, actually, of a question that it's a good question, but the answer could be easily found by just doing a search of the act itself. Since the question had to do with sentencing and circumstances where there is no mandatory minimum sentence, this is the kind of question that you should be able to search on your own. And this is something that I'm trying to encourage you guys to do. Before asking me, I want you to try and put those legal research skills that you've learned in school into practice, because when you're actually in the field, you're not always going to be able to ask somebody to give you all the answers. You need to be able to find the answers for yourself, okay? So the answer is contained within the act itself. It's great. If you know you have a piece of statute law, that's great, because then you have a place to find the answer. So in this case, it's the CDSA. It's under Part 1, called Offenses and Punishment, Particular Offenses, and it's under the section called Sentencing, okay? So first, I want to point out that in this section, it talks about the purpose of sentencing. It talks about factors to take into consideration when sentencing. And it talks about, under section 10, subsection 2, it says, if a person is convicted of a designated substance offense for which the court is not required to impose a minimum punishment, The court imposing sentence on the person shall consider any relevant aggravating factors, including that the person A, in relation to the commission of the offense, either carried, used, or threatened to use a weapon, or used or threatened to use violence, or trafficked in a substance included in Schedule 1, 2, 3, 4, or 5, or possessed such a substance for the purpose of trafficking in or near a school, on or near school grounds, or in or near any other public place, usually frequented by persons under the age of 18 years, or 4, that they trafficked in a substance included in Schedule 1 to 5, or possessed such a substance for the purpose of trafficking to a person under the age of 18 years. Okay, so these are the things that that they must consider. Okay, if it's a conviction that does not require to impose a minimum punishment, the court also should consider whether, in relation to the commission of the offense, whether the convicted person was previously convicted of a designated substance offense as defined in subsection 2(1) of the CDSA, or a designated offense as defined in subsection 2(1) of the Cannabis Act. The other thing that the court would have to consider is whether, like in relation to the commission of the offense, whether the substance or whether the convicted person used the services of a person under the age of 18 years to commit or involve such a person in the commission of the offense. Okay? Then it goes on to talk about reasons. So usually that speaks to reasons for the decision, reasons for conviction. It says, so this is again section 10, subsection 3. If under subsection 1, the court is satisfied of the existence of one or more of the aggravated factors enumerated in paragraphs 2A to C, but decides not to sentence the person to imprisonment, the court shall give reasons for that decision. Okay? It's worded right in the body of the act, that here are, in circumstances where there is no minimum sentencing requirement, here are the factors that the court must consider then when rendering their decision. And subject to these factors, then the court must give its reasons if they find that any of those factors have been or any of those factors apply in that particular case. Okay, so another student asked whether there was any relevance in marking, I think they meant to say marking the materials with particular colors while reading. They say, I ask this since you said if we know the spirit of law, we could answer the questions if focused. So this is talking about two completely different things. It's talking about color coding while reviewing your materials, so it speaks more to the Pretty Paralegal color coding guide, but it also asks or refers to being able to answer questions if focused, if you know the spirit of the law. Those are completely separate things. They're mutually exclusive, apples and oranges, and not an accurate representation of what I have taught. So let me explain it again. So first, on the topic of color coding, it's not a matter of whether it's relevant to color code while you study, but it's recommended. Because either way, when you review materials, you're going to highlight, right? Because you want to point, the purpose of highlighting anything is to highlight it. That's why it's called highlighting, right? You want to highlight the information so that it stands out from all the other information on the page. Many students will only highlight using one color. And the issue with that in an exam like the one you're about to write is that if you have to refer to your materials, which remember should not be your first step, because going directly to the materials is the fastest way to lose time in this exam. But if you have to refer to your materials, you need to be able to do it quickly. You need to be able to find information like in lightning speed, because you have less than 2 minutes to answer the question. And by the time you even get to referring to your materials, it probably already took you a minute or so to fully comprehend the question and the answer options. So when turning to your materials into a particular section in the materials, if you only have one color, then it highlighted, or if you've only used one color to highlight with, suddenly you're in a situation where you're looking at a page of yellow. You have to literally read every single one of those highlighted portions to be able to find where the information is. But if you use different colors to categorize the information that you're highlighting, it makes it a lot quicker to find answers. For example, if you use purple to highlight authorities, things like the names of statutes or the names of cases, and the question is asking you for to explain the definition of something, which is highlighted in yellow, then you'll know when you get to a page that has different colors on it, you're not going to look at anything that's green. You're not going to look at anything that's purple. You're going to look for anything that is highlighted in yellow, because yellow means definitions. So you save yourself some time. Similarly, if you have a question on the exam that requires you to look up the name of a specific case, like the leading case, for example, the leading case for voluntariness is R.V. Oikel. And if you need to find, what was the name of that case again, where they set the legal test for voluntariness, giving up information voluntarily to the authorities? What was the name of that case again? You're going to turn to the appropriate page in your materials, and you know that it's the name of a case. So that means it's an authority, which means it's in purple. So when you turn to the page, you're not, or to that section in your materials, you're not going to look for anything that's pink. You're going to ignore anything that's orange, anything that's blue, and you're only going to look for that which is highlighted in purple, because those are the authorities, and it will save you time. So that is the purpose of marking with multiple colors. And, you know, I want you guys to succeed, so of course I'm always going to be really honest and direct with you. At this stage in the game, we've now been in this program for several weeks. At this stage, it's kind of late to be asking this kind of a question, because this is the kind of thing that should have already been put into practice before we even met for our 5-week classes. So if you haven't already been applying this strategy, you know, we only have a few weeks left before the exam. And so I strongly encourage that you get to applying it, because this is hands down one of the fastest ways to save one of the best ways to save yourself time in the exam when you need to refer to your materials. Now, speaking about the other half of the question, which had to do with, you know, why do we have to highlight if we in different colors if we understand the spirit of the law, and could it just answer the questions if we're focused? Answering the questions correctly isn't just about being focused. You could be focused, but focused on the wrong things. You want to make sure you're focused on the right things. So highlighting helps you to do that if you have to refer to your materials. Understanding the spirit of the law has more to do with helping you to understand how to apply rules of law to a specific case based on each specific set of facts and information that is given to you on the page. So, I say that you don't necessarily have to have a perfect knowledge of the law. You just, in this exam, you need to be able to be resourceful, to be able to find the answers when you need to search for them. But more importantly, the most important thing is understanding what you're being asked to do. Not generally just what is the question, but what is the question asking you to actually do. And a lot of the time, the information, the answers, everything's right in front of you in the scenario. So yes, focus, I guess, does apply in this case, but it's about what you're focusing on. So just really focus on the steps, the 8 rules. Like, I can't say it enough. So a student asked whether it is 100% guaranteed that they will pass if they follow the 8 rules. Specifically, if the first step is to read the question first. And they also wanted to know what percentage of a chance do they have in passing by following the 8 rules. Okay, so first of all, I've said this before. I cannot guarantee that you will pass the exam. Just like I cannot guarantee to a client that they will win their case, even if it's a strong case. You never, ever, ever tell the client that you can guarantee that they're going to get a judgment, because you can't guarantee it. You don't know how it's all going to play out. I don't know each and every specific question that is going to be asked of you, so I cannot know how you're going to perform on it. But what I do know is that the 8 steps, the 8 rules, most definitely increase your chances of passing. I mean, I've demonstrated it for you in the class, how by applying the strategies I've taught you, you can answer the questions without even using the materials, because everything is written for you. It's right there in front of you on the page. If you understand what you are being asked to do. So when I say read the question first, obviously not all questions on the exam are going to be worded as traditional questions. Sometimes they're going to want you to complete a statement. Sometimes they want you to figure out what the exception to a rule is. And so it's an inadvertent question. So that's why I've been teaching you guys in our one-on-ones to rephrase it. Start with the last sentence to figure out what exactly it is that they are asking you to do. That's the key thing. You need to say to yourself, actually say to yourself every single time, what is this asking me to do? Because when you say that to yourself, your brain processes it a different way. It forces your brain to think of things a little bit differently. The reason why it is important to start with that first before beginning at the top of the case scenario is that if you need more context, first of all, by understanding what it is that they're asking you to do and then reading the answer options, you can often decipher just on logic alone what the answer is, or at the very least be able to weed out 2 answer options that logic tells you cannot be correct because of the language that is provided to you in the question as well as in the answer options. If you need more context, then you go back to reading the whole case scenario. The difference between reading the case scenario after you've understood what you're being asked to do is that you're able to ignore any information in the case scenario that is completely irrelevant to the question. As I've demonstrated for you most, if not all of the time, these case scenarios are going to give you information that is not relevant to the specific thing they are asking you to do, to the specific question. So you save time by only focusing on the information that is going to get you to the answer, right? We've gone through this, it's been demonstrated. Whereas if, so this person who's asking the question has written the exam multiple times, as they say in the way they've worded it to me. So they said that in the last 2 times that they wrote the exam, they went directly to the case scenario in order to answer the question. And I say this in as loving a way as possible. That obviously did not work very well because they've tried it, it didn't work. And that is the fastest way to lose time, because you're going to often have case scenarios that are very long paragraphs. It may take you the whole 2 minutes just to read the whole thing and even understand it. And the problem is that by the time you've finished reading and understanding the whole scenario and you get to the question, you might just confuse yourself because you don't actually know what's relevant and what isn't until you know what you're asked to do. That is why the first step is become clear on the question. Read the question first. Understand what it is that they're asking you to do, and only focus on any information that is relevant to answering that question. That is your only objective in this exam, is to answer questions or to complete statements. Basically, you want to be clear on what it is you are being asked to do, and focus on that and nothing else. Anything else beyond that information has no relevance to you and is a waste of your time and will cause you to not finish the exam. So, can I guarantee that you will pass the exam by following the 8 rules? No, I can't. Because it really comes down to you. It comes down to you following the steps exactly as taught. If Glenda could pass on her first try without having even read half of the materials, as somebody who doesn't test well, but she passed on the first try simply because she followed the rules exactly, then I am confident that you can do the same. But it comes down to you. And usually, in my experience in teaching in this program, the students who do not follow the steps exactly, or who kind of want to just go with their own sort of way of doing things, don't often do very well. So this has been developed a very specific way because it works. But at the end of the day, it's going to come down to you, and whether you trust in the process, and whether you put practice into it, whether you apply your clue words, look for definitive language in the answer options, whether you are able to discipline yourself to stop and consider, am I injecting information and context into this situation that isn't even here? You have to be able to practice those things for yourself and apply them in every single circumstance, in every single question that is being given to you. And that's really what it comes down to. And I have no control over how you do that in the exam. So I can't give you a percentage, but I can tell you that this process and strategy does work. So the last question is, I was asked whether you need to bring short notes on anything, things like charter types, or and what the relevant short notes to bring would be. So that all depends on you. I have given you some cheat sheets that I think are very important for you to have. But the point is that it's an open book exam. You can technically bring anything with you. You can bring every single textbook you ever purchased while in school with you. But I don't recommend that you do that because you don't need to. And the more materials you bring and rely on and use, the more likely you are to lose time and not finish the exam. That being said, I recommend that you do bring additional notes or cheat sheets for reference on any topics or just anything that's going to help you. If you struggle with a specific thing, take notes and bring those notes with you and just organize them. So what one student did in the last round, so he had everything, all of his materials organized by area of law, the pretty paralegal way, and color coded and everything. And then he created a separate pile, which were all cheat sheets and notes. And he was able to kind of really just focus on the things that he struggled with in that pile. And he could refer to them during the exam if those problematic areas of law or topics came up for him. And he passed the exam. So it really comes down to you. You can bring anything. But I would keep whatever you bring to a minimum and only focus on bringing additional paperwork if it's truly going to help you with something that you struggle with. So that's all for now. Thank you so much for writing in your questions. Hopefully I've answered them. If I haven't done a sufficient enough job in answering the question, please definitely send an email and let me know. And then that way we can discuss it further. It's Monday, so please write in some more questions. I love these questions. They're actually really great for me as well because it fortifies my knowledge and resourcefulness as well. And other students will be able to see this in the future, and hopefully these questions will help them as well. So I appreciate your questions so much, and I'm proud of you for having the courage to ask them.